and gentlemen, to the 7th EFILA Annual Lecture. It is really a very special day today, not only because the sun is shining in Brussels, which is very unusual. A good friend of mine always told me Brussels is the 50 shades of gray, but not today. And actually, it is a perfect timing because I understand that there will be new restrictions coming in tomorrow and on Monday. So we can still enjoy a little bit of freedom today. And the Press Club is really a very special place for EFILA and this series of lectures, because we have done practically all our lectures here, actually all of them, unless they were sort of cancelled by external factors, such as the horrible terrorist attacks in 2015, where we did it in London, and that was with Sophie Nappert. Then we had Johnny Feeder in 2016. In 2017, we had Judge Christopher Greenwood, followed in 2018 by George Berman. In 2019, we had Professor Laurence Bosson de Chazonnet. And last year, online, we had Professor Lucas Mistelis, who is also the chair of the executive board of EFILA. So this stellar lineup of speakers will be continued today by Annette Magnusson, the climate change lawyer, I can say. In fact, already, I don't know if you remember that, but already in 2015, at our very first EFILA Annual Conference in London, you spoke already about the interaction and possibly the tension between investment treaties and environmental law, generally speaking. So I think you were really a true pioneer, and I think you continue by raising the awareness, not only as you did as Secretary General of the Stockholm Chamber of Commerce, but since recently by opening up your own consultancy firm with a name, Climate Change Council, right? So I'm really very pleased and honored that you accepted our invitation. And indeed, the timing could not have been better, because the COP26 will start Sunday, I understand, Monday. We have the ongoing modernization process of the ECT, and we have the new Vice Secretary General here, I understand, of the ECT Secretariat. And of course, we have the ban on ISDS imposed by the Comstroy judgment, and of course, again, this week by PL Holdings, right? So there's a lot going on in relation to the interaction between investment law arbitration, and environmental policy general, and particularly climate change and climate protection. But before giving you the floor, Annette, please allow me to say a few words on the upcoming EFILA events. And the first one is going to be our next flagship event, and that is the annual conference on 4 February 2022, hopefully in person in Amsterdam. You see the flyer on your chair, and you see it here. This time we selected as a general topic, is the EU still an attractive investment destination? Question mark. Why did we do that? Well, as I said, here, not far away, a lot of things happening that I would say are not very helpful for the investment climate in the EU. But we will discuss this with really a stellar panel. And most importantly, I'm very pleased about that, we have as a keynote speaker everybody knows her under Jackie, the Director General of the LCIA, and that is a true honor. You can register now at Eventbrite with an early bird ticket until 1st December. So do have a look at it. It is worthwhile coming to Amsterdam for February. Second, I would like to mention our other very important activity, and that is the European Investment Law and Arbitration Review. This is the 5th volume. You can order it online at Brill, and the next issue is in print now or in production and will come out this December, just before Christmas usually. It is really interesting because the first article, the opening article of this issue is by Sarah Vazani and Nathalie Allen, entitled "No Green Without More Green: The Importance of Protecting FDI Through International Investment Law to Meet the Climate Change Challenge," which fits exactly the topic of today. So we have also a flyer on your chair for a 25% rebate until the end of this year. And maybe more importantly, we also have a call for papers, which will come out in a couple of weeks. The deadline is 1st of April, usually. And we would really very much appreciate your contributions. And it is, of course, a peer-reviewed journal. So we do also publish critical pieces, just to be very clear. It's an academic journal. Thirdly, we also want to establish a Young EFILA section. Like everybody else, all organizations, we also decided we cannot stay behind, and we want an EFILA Young section or a Young EFILA section. So in the coming weeks, we will develop our plans for activities, and we already have the idea to have an event back-to-back to the annual conference, so on the 3rd of February in Amsterdam. And if you are interested in being part of EFILA as a Young EFILA member, and you're interested in investment law generally, EU law, and all the interactions, it's free for now. So do contact me and we will sort this out. But this was as far as the promotional tour goes. And I don't want to waste more time with reading out your CV. You are I think, the globally recognized thought leader on this issue of climate change and investment law. So I leave it like this. For the program, so after the lecture, we will have a Q&A session. And hopefully also we can feed in some questions from the online participants. I will see them hopefully on my iPad and be able to feed them in the discussion that we have in the room. Of course, that's not going to be easy, but I will try to make a selection that fits the discussion here. So, and about 6:30, 6:45, we will have our well-deserved drinks. And then we can continue our discussion and continue the networking. And around 8, it's done. And finally, but certainly very important, I have to thank Kubas Kos Kalkowski, or KKG, our sponsors, not only of this EFILA lecture, but of all the EFILA lectures in the past. KKG is a Polish law firm, and they are also EFILA member. Unfortunately, none of the partners of KKG could make it. We have to do it with a logo, unfortunately. So without much further ado, Annette, the floor is yours.
Thank you very much, Nikos. I'm glad you reminded me of that event in 2015, the EFILA conference, because that actually set a lot of things in motion. It was the very first, as you mentioned, right? The EFILA conference. And I think also, so it ended up being the Stockholm Treaty Lab, actually, and that discussion sort of started in my head after that conference. Which was, for some of you might not be familiar with, the crowdsourcing competition we did a few years ago in Stockholm on sort of how to marry the different perspectives of climate change investments for the future through a crowdsourcing competition. But I also think, when I think about that conference now, I think none of that could have happened had it been online. So it is important that we sort of meet like this, and I'm very glad that we can be back like this and meet in person. And this is actually the first sort of in-person talk that I do after the pandemic, and also since I left the SSC. So it's sort of a lot of things in my mind as I was traveling here from Stockholm. It's sort of like nothing has changed and everything is different at the same time. Maybe many of you have the same feeling when you move around these days, that, you know, some things are exactly the same, but then again, everything is different. So yeah, a lot of things going on in my head. So thank you for that. So we will talk about Energy Charter Treaty Arbitration and the Paris Agreement, Friends or Foes is the title I put on this lecture. And I will come back to this sort of questions throughout the lecture. But just as a brief background then to this topic and that I will be addressing is, briefly, I would like to mention that if the world is to meet the climate goals, and I think by now most states and most countries, they have committed to net zero carbon emissions by 2050 or earlier, and you have a lot of corporations doing the same thing. And you have a lot of corporations and states looking also not only to have net zero by 2050, but to reduce their emissions by 50% until 2030. If we are going to reach these targets, all lawyers must play a proactive role and engage in accelerating these targets and accelerate the transition. I think this was probably best said recently by the US Special Presidential Envoy for Climate, John Kerry, when he was speaking earlier this summer to the members of the American Bar Association. And John Kerry said, "You are all climate lawyers now, whether you want to be or not." And John Kerry said, "We need your skills, your expertise, and hard work to lay the legal pathways and to expedite our progress." And of course, at Climate Change Council, we could not agree more. In this year in August, the Intergovernmental Panel on Climate Change, IPCC, reported that human-induced climate change is already affecting many weather and climate extremes in every region across the globe. And the IPCC also reported evidence of observed changes in weather extremes, such as heat waves, heavy precipitation, droughts, and tropical cyclones. And in particular, that their attribution to human influence had strengthened since the previous assessment report in 2014. So climate change is happening now, and we see this close to home for many of us. And for example, I know that here in Belgium, you saw it in the summer in July with the flooding, and we have seen flooding in Sweden as well, and we have seen that across Europe this summer, and these are just examples of what we have seen recently. So we do not need to consult the IPCC report to get a sense of what's going on. At times, it is enough to follow the news, where we can see the noticeable effects of temperature increases and the weather events mentioned by the IPCC report. And this has really brought the climate change issues into the mainstream view. So speaking then about mainstream view and the media outlets, as mentioned, today we're only a few days away from the COP26. So of course, the COP26 is dominating a large portion of our daily media reporting. And an important element of the expectations on COP26 that have been building up strongly, and I think even more so since we did not have a COP last year as planned, but this is postponed for 1 year. The expectation is building up that the outcome of the meeting will support the development of long-term and stable policies for the transition. But the necessity of energy-related infrastructure investments is very much part of the discussions leading up to the meeting in Glasgow. It is a vital component of whether governments will be able to deliver on their climate change commitments and meet the 1.5-degree targets. Now, of course, the calls for long-term and stable policy to foster investments in support of climate change mitigation and adaptation measures is not new. We have heard this for many years. We have heard this for a long time, not least from business side. Policy needs to be long-term, it needs to be stable, it needs to be transparent, it needs to be predictable, it needs to instill confidence to have these investments happening. You could say that the importance of energy investments is also illustrated by the International Energy Agency's report from earlier this year in May, where in their net zero by 2050, a roadmap for the global energy sector, and here in the pathway for global net zero by 2050, as outlined by the International Energy Agency, includes efforts in many areas, including large investments, innovation, skillful policy design and implementation of this policy, technology deployment, infrastructure building, and international cooperation. It's a big package of things that need to happen. The IEA emphasizes that investments to reach the net zero target includes an historic surge in clean energy investment, no investment in new fossil fuel supply projects, and no further final investment decisions for new abated coal plants. So to summarize where we are, the climate change crisis and the Paris Agreement targets clearly sends us in the directions of very large investments in energy. Which brings us, of course, to the Energy Charter Treaty. Now, of course, this audience, you are no strangers to the Energy Charter Treaty. The ECT is held by some as the most important of the bilateral and multilateral trade agreements that govern trade and cross-border investments in energy and energy-related transactions. Signed in 1994, the ECT resulted from an international effort to facilitate cross-border energy transactions following the end of the Cold War. And today the ECT has more than 50 state signatories from Europe, Central Asia, and other regions. The ECT establishes a framework for cooperation in the energy industry. It provides for free trade in energy products and freedom of energy transit and certain investor protection, and it aims to stimulate foreign direct investment in this area. So, as was mentioned before by Nikos, and as I'm sure you are all familiar with, the ECT is currently undergoing a thorough review. This is commonly referred to as the ECT modernization process. And the member states have undertaken several rounds of negotiation, including 3 rounds in 2020 and 4 rounds so far this year, and I think there's one coming up in November. And one of the most debated issues in the modernization negotiation and this process is whether and how the ECT should be revised to align with the global climate goals and support the clean energy transition. The fact that the ECT provides equal protection to all investments in the energy sector, regardless of whether the energy source is fossil fuel based or whether it's renewable, is one of the elements in this debate. One of the observations in this context is also that the IEA investment recommendations in the report that I just mentioned, the rise of clean energy investments, no new investments in fossil fuel supply, no new investment decisions in unabated coal plants, it could be said that these recommendations could stand in contrast to the Energy Charter Treaty, which is fuel and technology neutral and protects all investments in the energy sector, regardless of the source. And we will come back to this. Just a few words then about the Paris Agreement. So the Paris Agreement, as you know, has been ratified by 191 states and the European Union, and it represents today about 98% of the world's emissions. So there is a near universal global consensus on the need to reduce greenhouse gas emissions and to limit the global average temperature to preferably less than 2 degrees or even more, so to 1.5 degrees Celsius, not higher than this above pre-industrial levels. Now you are familiar with the concept of the NDC, the National Determined Contributions, which is the parties to the Paris Agreement setting their targets under the Paris Agreement and communicating them to the UNFCCC. And again, these NDCs typically aim to cut emissions significantly by 2030 and to attain climate neutrality, or net zero, as we call it, with carbon emissions by 2050. Now, it is widely recognized that reaching these targets requires an unprecedented overhaul of our energy systems around the world, including, most importantly, a transition away from coal, oil, and gas and to renewable energy sources. And from what we hear so far on the NDCs being reported, not enough, the ambitions are not high enough. So more needs to be done and ambitions needs to be raised. There was a report released as late as today, actually, from titled "The State of Climate Action." And this, the authors of this report come from several different organizations: the High Level Climate Champions, Climate Action Tracker, Climate Works Foundation, the Bezos Earth Fund, and the World Resources Institute. This report, The State of Climate Action, says there are a number of bright spots in climate change mitigation, which is good news, right? So we have seen an exponential growth in wind and solar power over the past 2 decades. So there are good things happening, but also the report points out, and this you can find from other sources as well, the public and private sectors must continue to step up and accelerate the investments needed to maintain a climate safe world for us all. So where then does the ECT fit in all of this? There is a broad spectrum of views on how the ECT fits into the context of the Paris Agreement and the clean energy transition. On the one end of the spectrum, it is held that the current version of the ECT supports the energy transition by encouraging and protecting investments, including those in renewable energy, and holding states accountable for regulatory changes, including those affecting the energy transition. It is said that an investment treaty is not the right place to implement global climate targets, and that the ECT therefore should remain technology neutral and leave it up to governments to implement the necessary policies to achieve their desired energy mix. On the other end of the spectrum, it is said that the ECT hinders the energy transition by protecting fossil fuel investments and using tax money to compensate fossil investors. Investor claims under the treaty, or even threats of such claims, are deemed to cause what we refer to as a regulatory chill that restricts states' ability or willingness to change laws and policies in the energy sector. Some argue that the only solution, therefore, is to abandon the ECT, while others advocate for a thorough reform of the treaty's language. Which, of course, brings us to the main question here. ECT and the Paris Agreement, friends or foes? To explore the answer to this question, Climate Change Council is currently doing a study of the available ECT awards to assess the ECT's interaction with the clean energy transition. This study is a project under the umbrella of the Net Zero Lawyers Alliance and funded by a philanthropic foundation. And just briefly to mention about the Net Zero Lawyers Alliance, this is a platform launched in June this year to mobilize commercial law firms and lawyers for climate change mitigation and resilience. The Net Zero Lawyers Alliance is an approved accelerator for the UNFCCC Race to Zero program. So this means, for example, that member law firms commit to offer legal services that facilitate clients and their supply chains to implement net zero by 2050 strategies. So the study whether we are undertaken in this context is intended to provide an objective review of the ECT Arbitral Awards, and it is designed to assess the interaction between investor protection, energy transition policy, and climate change agreements. Through stakeholder interviews, review of available literature, and a thorough review of the jurisprudence, this study looks at if and how arbitral tribunals in the past have weighed the treaty's investor protections provisions against the host state's energy policies and commitments under international law. What type of energy sources do investments consist of or align with? What role does energy policy play in the party submissions or in the reasoning of the tribunal? Is climate change related policy visible in these awards? Is it argued? Do the awards mention the Paris Agreement? And have tribunals in the past considered state actions motivated by international commitments sort of outside of the ECT? These are examples of some of the questions that we are asking. And perhaps now would be a good time to say a few words about what we're not doing in the study. We are not reviewing the tribunals or the parties or offering any view on specific paths relating to, for example, policy or applicable law that the parties or the tribunals should have chosen, in our opinion. Our purpose has been to view the awards through an energy transition lens and simply state the facts as we find them, not pass any opinion, but present an objective perspective to the best of our capabilities. In our stakeholder interviews and in the review of the awards, of course, many additional questions present themselves. How did, for example, the award in the end affect the general energy mix of the state? And the investors that received compensation, how did they reinvest? And does the mere threat of recourse to investment arbitration prevent states from taking measures that would accelerate the clean energy transition? These are all very interesting and very valid questions, but they go outside the scope of our study. Maybe a later study, who knows? But for this study, they are unfortunately outside the scope of what we're looking at. Other parameters to keep in mind is that first, this study is limited to ECT awards, but of course we know that parties and tribunals in ECT cases also refer interchangeably to other investor state cases under BITs. Second, we have not had a chance or an opportunity to review the parties' submissions, apart from the way in which they are cited or directly referenced in the awards. And finally, we are not entering into the discussion on the validity of the ECT in an intra-EU context. So then moving into some of the preliminary findings. Right now, we are in the middle of our analysis and crunching of the numbers. So what I will be sharing with you here are some of our preliminary findings. And the final report will be due at the beginning of next year. So looking then briefly at the numbers, what kind of investments are we seeing in these cases? Well, out of the 64 awards reviewed to date, 42% relate to investments in solar energy. If you add the investments in hydro and wind, renewable energy represents 52% of the investments in these cases. Oil represents 16%, and gas represents 12%. If we look solely at the awards relating to investments in fossil fuels, 36% of these relate to investments in what we call infrastructure. You have 29% relating to exploitation and 19% exploration. One detail which I think is interesting, if you look at the fossil fuel cases in isolation, but behind the numbers of these cases, we learned that they generally address sort of isolated issues that really have nothing to do with climate or energy transition. So in other words, these awards are not systematic in character. And that could be contrasted with the renewable energy cases, which are more about sort of changing the entire energy mix of the state. So that's the difference between these two categories of cases. The UNFCCC, the United Nations Framework Convention on Climate Change, is the main international treaty for climate change, which is sort of the framework convention from which all of the COPs emanate, right? So the Conference of the Parties is a conference of the parties of the UNFCCC. This is the main convention or the main legal instrument under climate change law. The UNFCCC, and I should say, was also entered into in 1992, for those who are not familiar with that, but I'm sure most of you are. The UNFCCC is mentioned in 19% of these awards, but only by way of background to the facts, sort of never in the analysis or the reasoning of the awards. For the Kyoto Protocol, which is the result, well, you're familiar with the Kyoto Protocol, so this is the result of the Conference of the Parties in 1997, COP3 at the time. We have one award where the protocol is referenced in the analysis of the award, but 78% of the awards have no mention of the Kyoto Protocol, that was difficult, at all. Is climate change an item discussed in the awards? Not really. Again, we have one case where it is mentioned in the analysis, but in 78% of the awards, climate change is not mentioned at all. So moving then to Article 19 of the ECT, where we find some interesting language on the environmental aspects. Article 19 of the ECT requires that signatory states minimize in an economically efficient manner harmful environmental impacts arising from energy use, and also that they take account of environmental considerations throughout the formulation and implementation of their energy policies. Now, of course, Article 19 of the ECT is found in Part 4 of the treaty, and the dispute resolution provisions in Article 26 of the treaty refer to Part 3 of the treaty. So, as I'm sure most of you will be familiar with. Still, we have found 3 awards where Article 19 appears in the tribunal's reasoning, and the language surrounding Article 19 in the awards is an area which we will analyze in more detail ahead. This holds potential interest. Moving on to the issue of applicable law, because one question which surfaced in the stakeholder interviews was the issue of applicable law. And I should say, when I say stakeholder interviews, it should be pointed out that the stakeholders we have talked to, we try to make a 360 sort of round on the different views that can be expressed on the ECT in the modernization process. So you would have, you could have the view from governments, the views from NGOs, the views from the ECT Secretariat, the views from people involved in international arbitration. So really the full 360 analysis. So I feel that's important to point out, all different angles coming in, and also views from the industry. So in this then, views or consensus on the interest of applicable law, what sources of law do tribunals use, and is climate change law part of the picture? As you will be familiar with, each arbitration case under the ECT operates under a set of procedural arbitration rules, and these procedural arbitration rules contain provisions on applicable law. So you find this in the ICSID arbitration rules, the UNCITRAL arbitration rules, and the SCC rules. And they all contain sort of similar applicable law provisions, in essence stating that the arbitrator shall decide the merits of the dispute on the basis of the law agreed by the parties, and that in an absence of such agreement, the arbitrators shall apply the law or the rules of law that it considers most appropriate, or language to that effect. So the parties, of course, making the choice in these cases are the state parties making their choice in the treaty. And in the ECT, the law agreed upon by the parties is specified in Article 26.6, which provides that an arbitral tribunal established under the treaty shall decide the issue in dispute in accordance with the ECT and the rules and principles of international law. And Article 26.6 has been held to have potential from a climate perspective, including in our stakeholder interviews, as I mentioned. Article 26.6 considers the treaty as a whole document, including the language on sustainability and energy efficiency in Article 19, it has been held. And it means also that the rules of international law can be applied as the applicable law in ECT investor-state disputes, meaning you include sort of the full spectrum of international law. So there is potential here, the view has been forwarded. And many of the stakeholders that we have interviewed formulate the opinion that Article 26.6 appears not to have been fully utilized in these cases, and that exploring the boundaries of governing law under the treaty would be of specific interest going forward. At the outset of this study, we thought that the most interesting point would be to see whether and how tribunals have interpreted the ECT in accordance with international environmental and climate agreements. It turns out they haven't. the fact that so few ECT awards mention international obligations regarding sustainable development and clean energy transition is an interesting finding. And in the absence of any precise example of climate change law being applied in the reasoning of the tribunals, could perhaps the principles for applicable law as used or as referenced to by tribunals, could this be of interest? Could this open a door for example, climate change law being present in the cases going forward? Maybe. This is something we will look at more closely ahead as well, but there is some interesting examples there. And that would include, for example, asking the questions if other sources of international national law than sort of what is evident from the treaty could influence when the exact boundaries and the definitions under the treaty are being carved out. For example, when it comes to the definition of legitimate expectations under the ECT. What other sources of law could be relevant for that? There is some interesting tribunal language that needs to be explored further on that topic. And then moving slightly more over to the merits and the energy transition. We have very few words to discuss or even mention an energy transition. Again, this is mostly in the backgrounds. So many, and energy transition appears to have motivated many of the measures later appearing at the heart of the dispute. Even though that's the case, this perspective does not seem to have influenced how parties have later argued and tribunals decided the cases. So when we see tribunals, for example, balance the regulatory interest of the states or the state's right to regulate with the investors' legitimate expectations, the state policies involved in this balancing exercise relate to, for example, budgetary concern, fiscal policy, or the cost of energy for end consumers. But there's really no policy directly relating to energy transition that is part of that balancing act. Many of the awards with investments in renewable energy turn on the fair and equitable treatment standard and the boundaries of investors' legitimate expectations. What does an insurance or a commitment from a government look like in a legal sense under this standard? And how should a change in the regulatory framework be assessed in this context? These are common questions and tribunals have answered them differently. But perhaps this is the part of the current jurisprudence that will be of the most interest for stakeholders going forward. Stakeholders looking to understand how future tribunals will respond to investor claims challenging state actions seeking to phase out fossil fuels in state ambitions to meet the climate targets under the Paris Agreement. The first of such, what you could call phase out cases, were filed under the ECT earlier this year. They were filed by the two cases we are familiar with are the RWE case, Germany's biggest coal power producer that filed a case, an exit case against the Netherlands in February this year, following the Netherlands' plans to end coal-fired power production by 2030. And in April this year, another German energy company, Uniper, filed a case also against the Netherlands, and alleging that the government's plan to phase out coal by 2030 violated the Energy Charter Treaty. We don't know whether we will see more of these cases going forward, but there might be more to come as more and more countries pass legislation aimed at reducing emissions by 50% by 2030 and to reach net zero by 2050. And I think these cases will certainly be a test for the Energy Charter Treaty and also for the people being involved in these cases. So as I conclude, I come back to the question, friends or foes? You might have made your own conclusions. My personal reflection as I come to this part is this. I have worked with international disputes for more than 20 years. During my time at the SEC, I probably have seen well over 2,000 disputes. And if there's one common denominator in all of these disputes, it's this. Disputes always represents a failure. A breakdown of relations, expectations not being met, something not being planned properly, something went wrong. And that's really regardless who is right or who is wrong from a legal standpoint. If you end up in a dispute, something went wrong along the way. There was a failure involved. In the dispute, you need to spend time and money to figure out what happened, who was responsible, how do we fix it? Can we fix it? Can we repair the damage? If you're in an organization, it doesn't matter if you're private or public, if you are a state or if you're small SME, managing a dispute is at the very bottom of the list of things you want to spend your time doing. And equally, it is at the very bottom of the list of things you want to spend your money on doing. And investment disputes, of course, are no different. And investment disputes take a lot of time and cost a lot of money. So the important question in my mind is, what can we learn from these failures? Because clearly there have been quite a few. And again, this is not a legal assessment. This is just observing. You have all these disputes. Clearly, there have been quite a few failures here. What we do know is that we need the energy transition to happen. And time and money needs to be spent on building for the future. In the IEA report that I mentioned earlier, it is pointed out that almost half of the reductions needed for the 2050 targets are expected to come from technologies that are currently at the demonstration or prototype phase. So this is where we need to put our time and our money to get these technologies ready, to make the necessary investments, to put these technologies up to scale and have them working. Investments need to keep coming. We have less than 10 years to the necessary 2030 milestone, and investment cycles for 2050 are happening now. So really, there is no time to, in my mind, to start from scratch and negotiate new multilateral agreements. We need to work with what we have. We need to listen to science, and we need to use the full spectrum of international law to the best of our capabilities as lawyers to get us where we need to be. So returning then to the question, ECT and the Paris Agreement, friends or foes? Well, I would claim that they are neither, because they appear to never have talked to one another. At least in the ECT jurisprudence, it seems as if energy investment law and climate law exist in completely different worlds. And in the absence of this, and the absence of a discussion of climate change and energy transition in these energy-related investment arbitration cases is, to be honest, quite surprising. We have looked at the past in the study, and we will continue to do so. And once the report is finalized by the beginning of next year, we hope that this will be helpful, and that 10 years from now, if we ask the question again, friends or foes, we hope that at that time, the question can be answered with an affirmative friend. Because the Paris Agreement needs all the friends it can get. Thank you.
Thank you so much, Annette. I think it was really very interesting, and it's quite interesting before we start the discussion, what you just mentioned about communication, because it was exactly the same point that George Berman raised here when he said that EU law and EU lawyers and EU institutions don't talk to the investment arbitration community and vice versa. It's exactly the same. So it's very interesting. I wanted to say funny, but it's not funny at all. It's really interesting to see that there's a parallel here as well. So at least we are here in the press club where we can talk and where we should talk. So I think that is really a very nice opening for the discussion.
Well, thank you. And I think the fact that we operate in different silos, it's not unique for the lawyers and our respective constituencies. It's just the way our society is organized. It's organized in silos. But when you want to have real progress, you need to sort of tear down the wall between these silos. And I think the climate change situation that we are finding ourselves in, you hear this all the time. You need to cross-fertilize perspectives, because that's when you have real progress. That's when really revolutionary things happen. It's challenging, it's difficult, and the rate of failure is probably larger. But when you have true success, it is when you have torn down the walls between the silos.
Yes. So let's do this. Who dares to ask the first question? Yes, Jose Angel.
Can you hear me? Yeah. Mrs. Magnusson, congratulations for your presentation. I have a comment / question regarding something that you, I think, rightly said during your presentation. You mentioned that the Paris Agreement has around 191 parties plus the European Union, and it seems to reflect consensus on climate change and even some aspects of energy. And taking this into account concerning the ECT, I was just thinking, of course, was a suggestion from your presentation that perhaps you recall in one case, recent case in Escosol versus Italy in 2019, the arbitral tribunal understood that when you have to interpret a treaty according to Article 31.3.c of the Vienna Convention, you must take into account all the obligations and other obligations, international obligations between the parties. And that tribunal understood that the reference to the parties means to all parties to the treaty. I was just wondering, because of, again, as a suggestion from your presentation, that perhaps we could take into account that all contracting states of the ECT might be, I haven't checked it, but I think so, at the same time, all parties to the Paris Agreement. So to some extent, some tribunals, and a tribunal might interpret the ECT in accordance with the Paris Agreement, because it is first lex posterior, and at the same time is another obligation or reflects obligations involving all parties to the treaty. I don't know if you have any thought about this.
I agree that one should explore as much as possible different ways in which you could sort of marry the obligations to the extent you could call them obligations under the Paris Agreement, to be picky, but sort of the ambitions and what needs to be done if you are a party to the Paris Agreement. At the same time, if you are a party to the ECT and in a dispute, to sort of, because that will be one way of getting that perspective into the reasoning. It has to start with us with the way the case is presented by the parties involved, and depending on where you are in the dispute. But I do think that it would be interesting if you would see that. And that's, like I said, we were surprised to some extent how absent the entire climate change law sphere appears to be in the ECT jurisprudence.
But maybe it is also a bit early. Maybe, I mean, in terms of when you look at when the case originated a couple of years ago, and that states and, well, mainly states are still stuck in their normal legal argumentation.
Well, if you think of the Paris Agreement, yeah, that's 2015. So perhaps then one could say it's early, but the Paris Agreement is not alone. So you could go all the way back to the UNFCCC. And if you look into the parallel universe of climate change litigation, there you see the presence of the UNFCCC in sort of the legal reasoning of courts, and that the UNFCCC brings with it certain obligations and expectations. So I'm not so sure that it's too early, to be honest. I think there's probably plenty to find if you want to go down that path.
Yes. Well, still interesting, the absence of it. But Yannick, you had also raised your hand, please.
Yeah, thank you. It's working. Oh, thank you very much for the inspiring talk about integration and advanced of the VCLT. You are discussing with us too early. I think that more generally, Article 31.3 is not very much used in investigate arbitration. So there are progress to to be made more generally to connect public international law regimes, the one with the other. Talking about your review of the case law, so you refer to the ethics and the legitimate expectation, which are very much important. I was just wondering whether you focus on the notion of due diligence, phrasing the legitimate expectation of investors, because this principle of due diligence can be an important channel to protect the regulations in favor of climate change, in the sense that you could argue that for an investor, especially in the future, could or should expect states to adopt legislations to protect and to meet their climate change objectives. So as you look at this notion of due diligence in particular.
So we that's part of what we're looking at, but we have when your comment makes me think of what I think I mentioned, where you could sort of have tribunals reasoning around how you fill out the legitimate expectations with what investors could reasonably expect that to be happening in the state regulatory field, given what's happening outside the state. So for example, within EU, right? If the EU has taken certain decisions, how could the investor expect that to influence the national legislation, and that sort of feeding into what is a legitimate expectation. So in that context, I think it's relevant, and I think that's one area which is really interesting to explore as we go further into the detailed analysis of all of the awards. We have not yet done this detailed analysis of all of the awards. We have done the surface analysis, which gives us the numbers, and then we will do the detailed analysis of all of the awards going forward. But I agree, that is an interesting, what could one legitimately expect? What that would happen given the universe, so to speak, that the state finds itself in. And I think the phase out cases probably will be very interesting from that perspective.
I mean, just to add to this, I mean, I think it's really an interesting question now, because when we look at the German Vattenfall case, you could say, well, you know, it was a sudden decision based on what happened in Japan, you know, rather ad hoc, but with regard to the climate change targets, they have been, you know, increased every year for many years. So you could argue and say, from an investor's perspective and due diligence perspective, well, yes, you should have been aware that the EU and the member states are going to increase rather than decrease the climate targets. So in that sense, I think it's quite an interesting question, whether you can legitimately still, so to speak, hide behind not having been able to expect certain measures being taken. I'm not sure, but it's an interesting question. Amaka.
Yes, thank you for the really insightful introduction and discussion of the project you've been involved with concerning the Energy Treaty. Now, listening to you, I see basically three things at play here. First, the Energy Charter Treaty itself, then Energy Charter Treaty arbitration, and then post the Paris Agreement itself. So listening to you, the impression I get is that the Energy Charter Treaty itself actually makes some kind of provision, even though in more general terms, for this energy transition, because it refers to all the relevant rules of international law, including environmental law, and then as you point out, the settlement provisions would also apply to issues raised by the energy transition. So I'm just really curious as to why in popular discussion, as well as also in academic discussion, is the Energy Charter Treaty pointed out as to blame for the fact that the energy transition is not proceeding very quickly. I was probably listening to discussions on this, and the Energy Charter Treaty is always pointed out as a big obstacle to the energy transition. But then this seems to be a bit in opposition to what I hear from you now, that there are actually provisions in the electoral treaty. So what is it then in the treaty that, or to put it differently, do you really see the electoral treaty as it exists now as a problem? So that's my first question. And the second question concerns is also related to the issue of the legislative interest of the investors, because there's also this discussion as to how the measures being taken by states right now in terms of stopping, for example, the operation of coal mines, etc., have been quite abrupt and have occurred in such a way that companies themselves are deprived of income that they could have actually used to invest in building more sustainable energy solutions. I'm just wondering, does the energy treaty in a way make provision for balancing the interests of the investors and the interests of transition in a way that actually supports the ultimate goal of the transition?
Those are two big questions. So if I start with the first one, whether the ECT is actually hinders the transition, I think much of the discussion around the Energy Charter Treaty in terms of this sort of debate on really is very similar to the general debate on investor-state arbitration. That's one observation that I have. So it's not unique for with the ECT. And when I say that, I mean that it's sort of you come into that discussion with and having a strong opinion in one way or the other, and that sort of influences the way you formulate your views in that discussion, and that not necessarily always digging into actually what's happening in the cases. And again, that's for the ECT cases and the general ISDS. That's just my experience, also from the back at the SSC. So that could be one element. I think why it is held that it hinders. Well, I mentioned a few of them. So it's perceived as when you have this technical or investment neutrality in terms of all types of energy are being equally protected by the ECT. That's being perceived at that end of the spectrum as that's one of the things that is against energy transition. If you are protecting actually, for example, now the fossil fuel phase out investors, if you're perceived as protecting them, whether or not the ECT protects them, we do not have the answer to that yet because these cases have just been filed. So that doesn't have an answer yet. The ECT itself is policy neutral. It's a legal document, right? So that's very much emphasized also by the stakeholders. That should be pointed out. This is a neutral document. It's really how is it being argued and what is happening in the cases, and if the policy is being assessed in the cases. So that's sort of why this is being held, that it's being hindering. And is there a regulatory chill? It's very difficult to measure something that doesn't happen, which is sort of the general. How do you know that something doesn't happen because of the ECT or because of another bilateral investment treaty for that matter? This is also a very difficult, or this is a generic debate, one could say, in the ISDS and the ECT sphere. And again, like I said, this is sort of beyond the scope of our study. If there was a way to measure it, that would be very interesting. So if someone comes up with a method, we would be happy to look at that. But I do think it's an important question to ask, because as long as we don't have a clear answer to that, there will just be speculation in one way or the other. And that, and again, will hinder us from actually doing what we need to do, doing the smart things and getting caught up in a discussion rather than going forward and do the things for the future. So while I've been speaking, I already forgot your second question. Sorry, what was that? All right, whether if you get the damages and whether you could sort of take that money and invest it in renewables or something for the future, right? Even if you are a fossil fuel company, that's what you're sort of asking. If you could balance, the ECT could play a balancing role there.
Yeah, I was just wondering to what extent.
So, like I said, what happens to if there is damage is being paid under the award, what happens to those damages? That's something we cannot see in the awards. But maybe that could be something that could be further investigated, and it is an important question, and that's a question that has been raised by several stakeholders, and because that plays into the bigger picture, right? The role of the ECT. But that would be something that would be next step if someone want to go in there. I'm sure there could be ways, maybe in public sources, to see where these companies were the investors. Okay, what were their next investment projects and what have you. But there's nothing in the jurisprudence that we have seen so far that will indicate that there is such a balancing function. It's just not really possible to ascertain from what we've been looking at. I'm sorry, I hope that answered your question.
Which is interesting because, of course, as you rightly said, most cases, ECT cases, are renewable energy cases. So if they're already bitten once, I'm not sure they want to go again into it and want to be bitten twice. So that's my personal view. Before we go to Lothar, we have a first question from our online audience from Dr. Kahner. Hello. The energy transition in developing or less developed countries needs more funds concerning possible arbitration cases, but Paris Agreement does not serve this purpose. What do you think about this? I'm not quite sure the question is clear.
No. So is this a situation where you have potential cases being filed, but there's a lack of resources from filing the cases? I think the observation is correct that the Paris Agreement does not help. If you're talking about an investor seeking to file a claim against the government, for the practicalities of that, the Paris Agreement does not help. So their assistance, if one could call it that, needs to be sought elsewhere. Yeah, that's one way of interpreting the question. I'm not sure I got it right.
Maybe you can, because we have an issue with the microphone. Can you stand? Yes, please. For the audience, for the online audience, because the wireless micro doesn't work.
Okay, well, the question actually made me think about the fact that the so-called developing countries probably are not always in a financial position to make the investments necessary for making the energy transition. So the question made me think about how do we reconcile any obligations under the Paris Agreement with the actual economic position of the developing countries, and whether there's some kind of provision or made to take into account the economic capabilities of the states concerned.
Yes, and this goes to the core of one of the larger issues in Glasgow, I think, when will the money come that has been promised to make all these investments for the energy transition? They were promised already in Paris. And I think, because if you look at the size of the investments that are needed, and many of them are needed in the global south, where you have, I think the latest number I saw, 800 million people who do not even have access to energy. And you have 1 billion people that have what is referred to as unclean cooking device, which is really polluting and causing them bad health. If you need to move that needle in those two numbers, you need large investments, and those investments, the funds may not be in the governments or at the states. So you need this sort of support to happening from global north to global south that has been discussed. So that's sort of, I think that's probably a parallel. That's a parallel discussion. It's not necessarily tied to the Energy Charter Treaty, in the sense that unless one takes the discussion on sort of the Energy Charter Treaty providing that investment security, and therefore lowering the cost of the investment, you have that legal security, and the ECT being part of that, that could be in a parameter. But I think the big question here is to get the funds.
Maybe that would actually be relevant for plans to reform the Energy Charter. This might be taken into account or not.
So the reform process making the ECT more of an accelerator for FDI? Yes, potentially. I think because whether or not the ECT or any of the bilateral investment treaties do in fact accelerate foreign direct investments or not, that's a debated issue. We do not have any clear research or studies or numbers pointing in either direction there. That's still an open question. Whether there was a way to make that question affirmative yes as an accelerator, that would be a good thing. I don't have that silver bullet, but I'm sure there's smart people out there that are thinking about that right now.
Well, speak of smart people, Lothar, while you go to the lectern, I can fill up the gap in the sense that, I mean, there is this new trend, very new trend, and maybe some of the Commission people can say something about this, is of course the facilitation agreements. What I understand is that the EU just started this summer negotiations with Angola for what they call an facilitation agreement rather than an investment protection agreement. So if you go down this route, right, this could be an interesting way maybe to think about different functions of agreements, not in this binary situation that we have investment promotion and investment protection, but rather more in investment facilitation or even acceleration, while at the same time sort of providing sufficient regulatory space. So that could be a new way forward. I mean, the negotiations just started. We don't know what's going to be coming out of this, but maybe this is the new trend. And after all, now since we are terminating the bids, it's time to get new treaties, right? Not less treaties. But over to you, Lothar.
Thank you. You said that disputes happen when things go wrong. Maybe you made this remark in particular in relation to investment disputes, but the point could be made more broadly. And I think there is a very large share of disputes which serve a very different purpose and are characterized rather by an attempt to test the limits. Think of people challenging corona travel restrictions or obligations to wear masks and the like, and certainly also on the trade agreements, very many legal disputes serve that function. Maybe the difference is that they're not individuals like the Citizens Against Corona measures, but often states who challenge each other's legislations. And that makes me think now of regulatory chill, which you observed at the beginning. It was not an important feature of your remarks, but it made me think whether regulatory chill is not at all a wrong label for what is being spoken about, because one would never consider human rights obligations, constitutional or international, as a chill or certainly undesired chill towards the exercise of legislative authorities or police enforcement activities. So that's precisely the purpose of these limitations. And likewise, international trade agreements contain disciplines precisely to intentionally chill against certain national trade regulations, and investment protection treaties also serve that function. And so the question is not about chill or not chill, but the question is about whether there are limitations, the disciplines are excessive, either because they were wrongly formulated or because they were wrongly interpreted and applied in rulings. And if that happens, obviously it's a serious matter, and you could say an undemocratic matter, because if there are democratic majorities for certain governmental interventions, then these should be possible and not be held back wrongly. So I return to the point: isn't regulatory chill absolutely a wrong label for what is being spoken about?
That's a very, very good observation, and it sort of shows the power of choosing your words and the terms, right? Because I think the same reflection that you just made about regulatory chill and the way this has sort of been, this term is being used to illustrate how certain treaty language, and here we're talking about investment protection, is sort of perceived as stopping governments from taking certain actions, and that being a negative thing, and therefore we call it a chill. The same sort of observations we have done in other forests when it comes to the policy space, whereas you want the governments to have its policy space, which is important. It's perceived that it's being described as important, whereas in some contexts, for example, in human rights, maybe you want the policy space to be actually very, very small, because you want the international agreement and treaty to be extremely strong on the government. So there's very little policy space, whereas in other areas, you want the policy space to be large. So there's nothing inherently in the word policy space that would make it large or small, because you understand the context. And it's exactly the same with the regulatory chill. So I thank you for pointing that out. And I think maybe we'll try to figure out a different term for that. It's just that this is the term that it's difficult to find completely neutral term, perhaps. But you are right in making the observation that it depends on the context in which you are sort of assessing or observing the mechanics, if one can call it that, of not doing something from the government side because of what is stated in an international treaty that you have signed.
All right. Any other question in the room? We have one question online, which is more, I think, a question of clarifying what you said or what you didn't say. It is from Helion Ordenadzizu. I don't know, very difficult to read. Thank you for organizing the event and for Annette to provide us with such a great lecture. I have a question, just to clarify. Could you explain why do you consider fossil fuel companies not to be protected by BITs or the ECT as of now, if I understood correctly your comment on this? As far as I understand, there has been research done already saying that there are many fossil fuel related plants that are covered / protected by BITs and MITs, but the question remains about knowing if a tribunal considers that there is a violation of a BIT or MIT in a specific context.
No, that's good. That question was asked. So to clarify, the Energy Charter Treaty is, like I said, it's neutral on the sources of energy being protected. So there's no conclusion one can draw saying that specifically fossil fuel is not protected by the ECT. And the commentator is absolutely right that and this will be true also for the so-called phase-out cases, that the tribunal will have to look at the specifics under the treaty to decide whether or not that particular investment in that particular circumstance, with the particular facts of that case, enjoys or does not enjoy the investment under the investment protection under the ECT. So it is neutral in that, if you look at the source of energy.
At least for now.
Yes,
I mean,
at least for now.
that is exactly the ECT modernization aspect that some are calling for, to carve out all fossil fuel investments / companies, and thereby carving out ab initio any disputes, a la the ones against the Netherlands, and as you said, potentially more down the line, right? But that is indeed the question. Is this the way forward to modernize the ECT and change the neutrality and do away with that? Because that would be a fundamental change of the whole concept of the ECT, right?
As I said, the one spectrum that does consider the ECT as hindering or standing in the way for the energy transition, that's one of the sort of the points in that, if one should call it group or camp or opinion, that the fact that the ECT is technology neutral, that is something that needs to be changed for it not to any longer be that hindrance to the energy transition.
Interesting. Any final questions, remarks? Don't be shy. This is a unique opportunity. Yes, Matteo, please.
Thank you, Nikos, and hi, Annette. Welcome back in Brussels. It brings together many questions on the floor today. To have a look at what happens after the arbitration cases, so both in terms of implementation of arbitral awards and in terms of regulatory life. So whether the awards influenced the let's call it energy transition regulation. So the question was whether you already plan to look into that in your work, or if you maybe want to consider it. And maybe just to link it to the other observation, whether it has an impact also on regional development policies, and in terms of what states do to implement the tools of the Paris Agreement to find finance for the transition in developing countries. So this is an interlinkages between arbitration, energy policies, and the regional development. Thank you.
But to the first question, I think we are collecting a long list of questions that we want to look further deeper into, sort of that are outside of this current study, but that could be relevant to trying to understand how we move forward, and how, again, I think our personal objective being how we can best facilitate this transition in one way or the other, using the legal tools that we have available out there. So yes, it's on that list certainly, to see what can go forward. And then when it comes to sort of the continued investments you were asking for, right? So what can go forward? I think anything we can learn from these cases will be valuable. If you have cases that have been the result of regulatory changes, and you have a dispute occur as a result of that, it's always tricky to draft policy. I have the fullest respect for how difficult that could be, in particular when you're navigating a new territory and trying to not least change the energy mix. And of course, the energy system does not operate in isolation. You have the entire economic situation in the world around you, and we are a very interconnected world these days. So whatever happens in one country soon translates also into your country. So it's really, really complex. But anything that can be learned from these cases, like I said, I think nobody but wants to end up in a dispute. So clearly something caused this dispute to happen. If things can be picked up, and then as we need a new policy to be designed elsewhere in the world, if this could be of any benefit for that, that would be a good thing. And I hope, and I believe there again are a lot of smart people out there that design policy, and I hope that they look at this jurisprudence. I hope they will take a look and see, why did this end up in a dispute? What can we do differently? So prevent us from ending up there, and prevent and enable us to spend our time and our money having this exponential growth, for example, in renewables that we need, rather than managing a dispute.
I think this is really interesting, and it brings up the comparison that you can make, and that I've also done in a couple of case notes, including the one I think in this review a couple of years ago, is if you look at the Spanish policy making in renewable energy and the Italian ones, you can see that obviously Italy received much less cases, and if I'm not wrong, won also most of the cases, in contrast to Spain, who practically lost all of them except the first two ones, right? More or less. So you can see that the design of the policy that the Italians adopted was at least a little bit better in terms of reducing reducing the risk of receiving renewable energy disputes. So there can be a lot done to essentially help protect the legitimate expectations of investors to such a level that it does not create a violation, right?
And I believe at times it could be as simple as the different branches of government speaking to one another to understand what is happening, you know, yeah, to really to speak to one another, so that the colleagues in another building or down the corridor that do maybe work with the investments and the others that work with the disputes to, and I mean, this is not unique for governments, I should say also, you know, you have this, I used to work in a fairly large law firm. You need to have the transactional people talk to the dispute resolution people, right? So you have this in all organizations, the different specialists. So taking us back to the silos. So, you know, the more we talk about it, the more we become aware about it, then we can, hopefully we could take a little away some of the bumps in the road going forward.
Well, I mean, actually, I think that is one of the things that, in particular, the OECD has been promoting for many years in its outreach programs, when it looks into the administrative functioning of the bureaucracies in countries, and to try to improve the communication channels, just to avoid misunderstandings, which then can become huge disputes. So I think there's a lot to gain here. We have now another question. I'm happy about that, from Emma Yanini from KNS. Hello from New York City. You see, so that's nice when we are online. Forgive me if this has already been answered, but do you think there is any possibility that ECT tribunals' reticence to refer to outside climate change law, i.e. the Paris Agreement, via ECT Article 26.6, comes from respondent states and the EC's, European Commission's, attempts after ACMEA and now Comstroy to use Article 26.6 as backdoor for the application of EU law? It would not surprise me that this would engender a reflex on the part of tribunals to interpret Article 26.6 narrowly, and therefore to not even think about possibly factoring in the Paris Agreement under this article as applicable outside international law.
So if I understand the question correctly, that just to avoid being drawn into undesirable application of European EU law, that would in and of itself prevent the application of international climate law, sort of. I don't know. It would not be for me. We will see.
I think it's a very, very clever question.
Maybe some tribunals got some ideas. I don't know what parties, who knows?
I think this is a very clever question. I mean, this goes back to a general principle question. What is EU law, right? Is it international law, or is it not international law? And you see that there is really a selective approach. Sometimes the European Commission and the member states say, well, no, it's not international law. And sometimes they do. And I think that's the same for tribunals, whether it's fact or whether it's law or something in between or both. We've seen that in different tribunals being used as seen fit. So I think it's a very, very clever question, but I think not something that we can answer. But thank you, Emma. Any other questions? I'm mindful of the time. It's exactly 33 past the hour. The drinks are ready. So it's the last round for you. I don't see any very urgent hands going up. Well, what can I say? First of all, thank you so much. I think it was really, as was said, an inspiring lecture, not a boring technical lecture, but an inspiring lecture, which we of course expected. And I think that was really interesting also, what Matteo also brought to the table is that this is not a binary issue, and that we need to break up the silos generally, and that we see that this issue here reaches not only to investment law and arbitration, it reaches to development policy, but it also certainly reaches out to human rights and to social rights and other aspects, right? I think one of the things that I learned, and I think that is probably the reason why we created EFILA in the very first place, is to get away from this black and white binary discussion, because it doesn't help. It doesn't bring us forward, because you don't actually listen, because everybody on each side believes that it has the answer, the right answer. And that is not the case. We will not have the right answer on the spot. It will take not only a lot of time and money, but I think it will also take a kind of like change of attitude. And you see that because funnily enough, actually today, for instance, Shell has also announced that it would actually speed up under pressure from shareholders, but still it does work to speed up the process of reducing their CO2 emissions. So what I want to say is that there are a lot of forces going on, including, again, also not only Dutch courts, but also courts in other member states who are pressurizing both member states, but also companies in doing more. And I think, as you rightly said, climate change or the fight against climate change needs as many friends as possible, wherever they come from and whatever color they have. I think that is really the message. So thank you so much. Thank you all for being so active. Thank you also for our online participants. And with this, we close. Thank you.
Thank you.
Bye-bye.